The Youth Law Centre is a free and confidential legal service for any young person in the ACT aged 12 to 25 years. The Youth Law Centre can provide young people with legal advice, assistance and representation. Often, legal advice can help you to better understand your situation and figure out which steps you should take to resolve your legal problem. The Youth Law Centre can also give you legal information. If you have any questions about the law and how that affects you, don't hesitate to contact the Youth Law Centre. In this video, we are going to break down what the rules are for cultivating cannabis in the ACT. Cultivation can include growing cannabis, harvesting cannabis, or nurturing cannabis. In 2020, cannabis was decriminalised in the ACT. It is important to understand that this does not mean that cannabis is legal. There are still laws that apply to cannabis which must be followed, and failure to adhere to these rules will constitute a criminal offence. In the ACT, it remains a criminal offence to cultivate any amount of cannabis if you are under the age of 18 years. If police find that you are under 18 and you are cultivating cannabis, even just one small plant for personal use, the police may charge you with a criminal offence. The type of offence that you will be charged with depends on the quantity of cannabis that you are cultivating. If you are over 18 years of age, it is not an offence to cultivate cannabis in the ACT. However, there are strict rules that apply to the cultivation of cannabis that must be followed to avoid criminal liability. The cannabis must be cultivated at a private residence where you live. This means that you cannot grow cannabis in a public place, such as in bushland, parkland, or on a nature strip. And you also cannot grow cannabis at a friend or family member's home unless you live there. Any cannabis that is cultivated must not be cultivated using artificial light, heat, or hormones. This means you cannot use hydroponic equipment to grow cannabis. The cannabis that you cultivate must not be seen by or accessible to any person under the age of 18 or the general public. And there are limits on the quantity of cannabis that may be cultivated. You must not cultivate more than 2 cannabis plants per adult person and no more than 4 cannabis plants per household. For example, John and Angie are 2 adults who live together in one household. They are each cultivating 2 cannabis plants. Their friend, Frederica, moves in with them later. Frederica is not permitted to grow any cannabis because there are already 4 plants growing at this household. You must also remember that it remains a criminal offence to sell or gift any cannabis that you grow or possess to another person, regardless of their age. If you are aged 18 years or over and you choose to cultivate cannabis, you must adhere to these strict rules. Failure to follow these rules will mean you are committing a serious criminal offence. Maximum penalties for cultivation of cannabis include fines of up to $8,000, 2 years imprisonment, or both. For larger quantities of cannabis, the penalties will be even more severe. It is also important to note that under federal laws, cultivating any amount of cannabis remains illegal. This means that even if you are 18 years of age and you follow the rules for cultivation of cannabis, there is still a risk that you may be charged under the federal legislation. If you are a young person aged 12 to 25 years of age with a legal issue or question, please do not hesitate to contact the Youth Law Centre at Legal Aid ACT for free and confidential legal advice from one of our experienced lawyers. To make an appointment, just call 02 6173 5410 or email contact@youthlawact.org.au. You can also message us on Facebook Messenger. Just find our Facebook page at www.facebook.com/legalaid-ACT. Our Youth Law Centre operates from 9 a.m. to 4 p.m. Mondays to Fridays.